Hi, my name's Alex. I'm going to speak with the Supreme Court judge to find out more about this court. Hi, Judge Shore.
Hi, Alex. Actually, as a Supreme Court judge, you would address me as Madam Justice Shore. But we judges also go by other titles. If you were writing to me, you would use the Honorable Madam Justice before my name. And if we were inside a courtroom, I would be called My Lady. And male judges are addressed as Mr. Justice, followed by their surname, and as My Lord.
Sorry, I didn't know that.
That's okay. Now, I understand you have some questions for me about how the Supreme Court works?
Yes, Madam Justice. I guess my first question is, what type of cases does your court hear?
It hears both civil and criminal cases, as well as some appeals from the provincial court. Usually, trials in the Supreme Court take longer before coming to trial and last many more days than trials in the provincial court.
How do you know which court hears a certain type of case?
That's determined by government legislation. The court must have the jurisdiction or the right to hear the case.
I think I know what a criminal case is. What do you mean by a civil case?
A civil case deals with unresolved conflicts between citizens, businesses, or government. Civil matters such as divorce, slander, libel, malicious prosecution, bankruptcy, personal injury claims, and contract disputes are heard by Supreme Court judges. So are judicial reviews of administrative tribunals, like the Workers' Compensation Board.
You said earlier that your court hears divorces, but my friend's mom and dad, they got a divorce, and I didn't think that they went to court.
Well, in order to get a divorce, you have to go to court. However, if you've agreed on all matters, such as division of property and the support of children, you may get a divorce by filing court documents, in which case you don't have to appear personally. Judges of our court also make orders about the division of family assets and custody of the children.
I see. So I've heard that people can represent themselves in court instead of having a lawyer. Can you do that in Supreme Court?
Yes, it's happening more often, but there's a lot you have to know. If you want to represent yourself, it's a good idea to talk to the BC Supreme Court Self-Help Information Centre in Vancouver, so they can help you understand the things you need to know.
Is it harder for you if a person doesn't use a lawyer for their divorce or trial?
Sometimes. There are a lot of rules regarding evidence and procedure, and most people don't know them very well. Because lawyers are familiar with the process, having one can help the trial go more smoothly.
Do those rules of court set out how a civil case starts? I mean, somebody has to want to take somebody else to court, right?
That's a great question, Alex. Yes, generally a civil claim is started when a plaintiff or petitioner files a writ and statement of claim or a petition. These documents explain the claim they're making. The defendant or respondent must reply to dispute the case. If Jones was suing Smith, the case would be called Jones versus Smith. This is referred to as a style cause. Now, you must file all your court documents at the court registry, where registry staff reviews the documents to make sure they're all in the correct form. You'll have to pay filing fees to start a case.
And if my claim is more than $25,000, I file in Supreme Court, right?
That's correct. I see you've learned a lot talking to my fellow provincial court judge.
I sure did. I also found out there's no jury trials in provincial court. Is that the same in Supreme?
No, in Supreme Court, we have criminal and civil juries who hear cases. In those cases, the jury makes the decision based on the evidence, and the judge's role is to explain the law to the jury. Often, a personal injury case will be heard by a civil jury. You're probably familiar with the 12-member jury in a criminal case, but a jury in a civil trial has only 8 members. And another difference, a civil jury doesn't have to reach a unanimous decision. As long as 6 out of the 8 jurors agree on the result and have taken at least 3 hours of deliberation. The civil jury can also make decisions on the amount of damages or money awarded in a case.
Who decides if there's going to be a civil jury?
The plaintiff or the defendant can ask for a jury to hear the case.
What happens if a plaintiff and a defendant in a civil case decide that they don't want to go to trial after all?
Well, the plaintiff can agree to settle the dispute at any time during the proceedings. A court case can be lengthy and expensive. Sometimes a settlement is the best solution for both parties.
Earlier you said that the Supreme Court also handles criminal cases and has criminal jury trials?
Yes, that's right. Serious criminal matters such as contempt of court, murder, manslaughter, aggravated assault, robbery, and major drug cases are heard by Supreme Court judges.
So in criminal cases, you always see case names like Regina versus Smith. Who is Regina?
Well, Regina is the Latin name for queen, and as the queen is the head of state in Canada, the government lays the charge using her name. A crime is considered to be an offense against the state.
Does the government have its own lawyers?
Yes, the government hires lawyers to act on behalf of the community and society. These lawyers are called Crown Counsel or prosecutors.
Are there criminal jury trials in Supreme Court?
Yes, the jury in a criminal case has 12 jurors who must make a unanimous decision.
Okay. And so the person charged gets to decide to have a jury trial?
Yes, it's called an election. It usually is made in cases where the accused could be sentenced to more than 5 years if convicted. For these more serious offenses, preliminary inquiries would have been held in provincial court before the trial is heard in the Supreme Court.
Okay. Is the preliminary inquiry like a trial?
Well, not exactly. A preliminary inquiry is a proceeding where the Crown has to present enough evidence to the court so that the judge will commit the accused for trial in the Supreme Court. However, the accused does not have to present a case at this time. Generally, at a preliminary inquiry, the defense counsel cross-examines the Crown's witnesses. If the defense counsel thinks that the Crown has not presented enough evidence to commit, he or she can ask the judge to dismiss the case at this point.
Okay. So an accused can elect to have a judge and jury trial. Are there any offenses where the trial must be by judge and jury?
Yes, for murder, skyjacking, and several other serious offenses, the trial in Supreme Court is by judge and jury, unless both the accused and the Crown Counsel agree to trial by judge alone.
What about in a murder case? Can the accused settle if he or she doesn't want to continue with the trial?
Actually, an accused can plead guilty and have a sentencing hearing rather than a trial. But once a person is charged with a crime, only Crown Counsel has the power to drop or stay the proceedings. The accused cannot decide to settle, as in civil disputes, and witnesses can't change their mind about testifying.
Okay, so suppose two men get in an argument. If one killed the other and was charged with murder, do you mean the friend of the accused who witnessed the murder would be forced to testify?
That's right. Witnesses to a crime are compelled to come to court to testify even if they don't want to.
It doesn't matter that the witness might also be friends with the accused and that they might not want to put their friend in jail?
Well, it might be an unfortunate turn of events in terms of their friendship, but they'd be obligated to testify no matter how they felt about it.
So I have a few more questions about your court, if that's okay.
Certainly. What would you like to know?
I guess the Supreme Court is a pretty important court, right? Can another court change or overturn a decision or order of a Supreme Court judge?
Another good question. Supreme Court orders can't be altered by the provincial court. Only the Court of Appeal for BC or the Supreme Court of Canada can modify or overturn decisions of the Supreme Court judges.
And how many judges work in the Supreme Court of BC?
The Supreme Court Act specifies that there will be 86 judges, plus the Chief Judge and Assistant Chief Judge. There's always a number of supernumerary or half-time judges as well. Now, these Supreme Court judges sit in 8 judicial districts. While the judges may work in a court near their home, they are also required to travel to other districts throughout the year to hear cases. You'll also find that there are Supreme Court masters who deal primarily with pretrial matters in chambers.
Is chambers like a trial?
No. Chambers matters are much shorter and usually last from a few minutes to a few hours. There are no witnesses in chambers, as all evidence is filed by using a written document called an affidavit. This affidavit sets out the evidence and is sworn by the person who's giving that evidence. If you have to prepare for a chambers hearing in family law matter, you could visit the website www.courttips.ca to understand the process and to see what the judges expect in your application.
So, do the masters make the final decision in the case?
No, in most cases, the judge or master in chambers will only make an interim order and will not make the final decision. That final decision will be made by a Supreme Court judge at trial.
How do you address a master? I bet they get a special name too.
They do. Masters are addressed as master before their surname, outside of court, and as your honor in court.
So, when a judge is making their decision, what type of things do they have to think about first?
Oh, there's some crucial things they must consider. Judges look at statute law, the rules of court, regulations, and case law when deciding a case.
Can you explain that a bit more for me, please, Madam Justice?
Of course. The rules of court govern the conduct of the case from filing the initial court documents to the conclusion of the case. For example, the order in which evidence is presented is a rule of court. Regulations set out practical information and procedures in relation to statute law. For example, fees payable for filing documents to get a case started will be stated in the regulations. Also, in order for the law to be applied consistently to everyone, it's very important that judges and masters follow the law as set out in previously decided cases.
Well, I know about that. It's called following precedent.
Exactly. Can I ask how you learned about that?
A Court of Appeal judge told me.
Excellent. Anything else about the Supreme Court you'd like to know?
This might sound stupid, but I noticed that you have a red and black robe on. I thought that Supreme Court judges only wore black robes.
It's not a stupid question at all. Black is the attire in Supreme Court if a judge is hearing a trial. However, we do wear red and black robes if we are hearing a murder trial with a jury.
Okay. What about the people who go to court to watch a trial? Is there a dress code for that?
Well, they must dress appropriately. That's not an amusement park. And you should conduct yourself in a courteous and respectful manner. There are certain protocols everyone must observe. When the judge or master enters or leaves the courtroom, a court clerk will say, "Order in court." At that time, everyone in the courtroom must stand. Sometimes you'll see people bowing to the judge as they enter or leave the courtroom. These are lawyers who are officers of the court. They're showing a sign of respect to the judge. It's a very old custom.
When is the court open for watching?
The judges of the Supreme Court of BC hear cases in court Monday to Friday from 10 a.m. to 12:30 p.m. and from 2 p.m. to 4 p.m.
I also have a question about a case we're studying in our class where a person was injured when a drunk driver hit his car. Is this the kind of case that will be heard in Supreme Court?
Well, that would depend on the amount of the claim. If the person was injured, he could start a civil case to recover money for damages to compensate for harm or losses that he may have suffered from the crash. If the claim was for over $25,000, then he would file a statement of claim in our court. If the claim was for under $25,000, then, as you know, he would file in small claims in the provincial court. Now, as for the criminal case, if the police believed the driver was drunk, he could be charged with a criminal offense. If the charge was impaired driving, it would be heard in the criminal court in provincial court. If the charge was for criminal negligence causing bodily harm, and the accused elected to have a trial by a Supreme Court judge, the trial would be heard in our court.
What should people do if they're going to be involved in a court case and don't know what to do?
A good place to start would be on the Supreme Court of BC self-help information website. A person could also talk to a lawyer.
Thank you for talking to me today, Madam Justice Shore. I really learned a lot.
I'm glad I could make things clearer for you, Alex.
You can find out more about the BC court system by exploring additional resources on the Law Courts Education Society's website. And if you want to better understand the reasons for judgment in cases recently decided in the Supreme Court, check out www.courts.gov.bc.ca. And if you're curious about the Provincial Court of BC and the Court of Appeal for BC, make sure you check out other videos on this website.